Ladies and gentlemen, welcome to Public Affairs Immigration Update on the Air. Longest running program on immigration issues, and our interviewee is Attorney Jack Golan, who has over 40 years of experience in immigration and nationality law. Well, today we'll be discussing immigration concerns, great news, interesting news, and many others, especially answers to your questions. Welcome, Attorney Jack Golan, to Immigration Update on the Air.
Thank you for inviting me. It's always a pleasure to be with you and with your viewers and listeners.
A lot of people are watching and they would like to hear from you about the great news on immigration.
Well, the most interesting news about immigration in the recent months was the development in connection with same-sex marriages. After the decision of the Supreme Court last year, when the Supreme Court invalidated most of the DOMA Act, the Defense of Marriage Act, and the state of California began to permit same-sex marriages, the Immigration Service also began to accept petitions by people who are married with spouses of the same sex, and approving petitions and approving green cards for same-sex marriages. This was the most interesting development in the last few months.
Mm-hmm. Well, that's really a very interesting news for our viewers today. Now, tell me, what would be the requirements to be able to file for legalization?
The requirements are exactly the same like any other marriage. Both parties to the marriage have to be free to get married, which means they cannot be married to anybody else when they get married to their spouse of the same sex. If they were married before to somebody else, they need to have divorced the previous party, whatever the sex. Okay? Now, this has certain implications to Filipinos, because even though in the Philippines the same-sex marriage is not recognizable and not permitted, if a Filipino in the United States wishes to marry another Filipino, or if a Filipina in the U.S. wishes to marry another Filipina who is now in the Philippines, of course they cannot get married in the Philippines, but a fiancé visa is available, which means somebody here, a Filipino or a Filipina here, may file a K-1 visa petition for a prospective spouse of the same sex in the Philippines. It will be approved by the Immigration Service in the United States. It will be transferred to the American Embassy in Manila, and the beneficiary will be granted a non-immigrant visa to come to the United States and to be married within 90 days after arrival. The sex doesn't matter.
Also, exactly the same as the K-1 visa, fiancé visa before. Within 90 days, they have to be married. And, of course, they will also be given a temporary card for employment, and just like the usual fiancé visa.
Everything exactly the same. Mm-hmm. There is some difficulty here because many times we run into a situation where the person in the Philippines, whether male or female, has been married before to somebody else. Now, in that case, a K-1 visa, a fiancé petition, cannot be filed for that person. That person in the Philippines, whether male or female, must obtain an annulment of the previous marriage. A divorce is not available, but an annulment can be obtained in the Philippines. After the annulment, a K-1 visa petition can be filed for that person.
Mm-hmm. Now, what about those that have children? Can they also be petitioned, just like a regular petition for children?
Exactly the same as a normal, a regular, I don't say normal because everything is normal today, as a regular heterosexual petition. If the beneficiary has children, those children are covered by the petition for the parent.
Mm-hmm. So let us just give all the different requirements necessary for this particular type of visa.
If we are talking about a K-1 visa, a fiancé visa, the one requirement is after we make sure that both parties are free to get married, one requirement is that the parties have met in person within the last 2 years, which means in most cases that the American petitioner must have taken a trip to the Philippines and met in person with his intended spouse within the last 2 years. Upon return to the U.S., as long as 2 years have not gone by, more than 2 years have not slipped by, the American citizen may file a petition for the prospective spouse.
Now, when the fiancé arrives in the United States, they are given 90 days to get married to that individual who petitioned for him or her. And then if they don't get married, what happens?
If they don't get married, then the person from the Philippines who arrived here on a K-1 visa is in great trouble, because the law says that anybody who comes to the U.S. on a K-1 visa and did not get married to the petitioner within 90 days cannot get any other kind of visa in the United States, which means they cannot get a green card in the United States. Actually, they must leave the country and go back to the Philippines.
That means to say if they meet somebody else and gets married to another individual, then that is illegal.
No, it's not illegal. The marriage would be legal, but they will not be able to get a green card in the U.S. They would have to leave the U.S., go back to the Philippines, and wait for a consular interview in Manila to apply for an immigrant visa in Manila, which of course raises the question, how long did they overstay the K-1 visa? Because if they overstayed the K-1 visa for more than 1 year, they would be barred for 10 years from coming back to the U.S.
Now, if everything was followed, the fiancé arrives here, they get married, what happens next?
If they get married, they need to file an application for adjustment of status. They don't need a new petition, just an application for adjustment of status. And the Immigration Service will give the person from the Philippines, male or female, his or her green card within the normal time, within the 3, 4, 5 months. That's a regular case. What is more interesting is that according to recent judgments, if the marriage does not hold up, assume that those people got married within 90 days, but for some reason the marriage falls apart, the person from the Philippines may still file an application for adjustment of status and get a green card, even if this person is not married anymore to the petitioner, as long as there was a marriage within 90 days.
I see. So what does she have to do, or he has to do?
She or he. Well, they need to get married.
No, but meaning to say, for example, there's trouble in the marriage in the first month. Like they remember sometimes there's domestic violence, etc. So what happens?
Well, if there is trouble, it would be advisable to document the trouble, to have witnesses, to have documents, to have proof that there was at least a good intention, a bona fide intention to establish a family. At least this, there was an intention to establish a family. And then the marriage fell apart. If it fell apart, that's not anymore a problem for the beneficiary. The only obligation the beneficiary has is to get married within 90 days.
What happens, Attorney Golan, if the petitioner passes away?
For sure, this is not the fault of the beneficiary unless the beneficiary was active in having the petitioner pass away.
But because sometimes, I thought a long time ago they say you have to be married for 3 years before you can apply for citizenship. Is that correct?
This is passed. This law has been cancelled by some other laws that were passed about 4 or 5 years ago. So this is no problem anymore.
So it's really no problem if the petitioner passes away and she or he is still married to the petitioner, right?
No, this is no problem.
Now, going back to the children left behind, if there are children left behind, when can the petition start?
Well, it depends how old are the children, As a matter of fact, if the children were at the time of the marriage, at the time of the petition was filed, the petition were under 21, or let's be more accurate, at the time that the non-immigrant visa were issued by the American consul in Manila, if the children were under 21, they will be able to come to the United States as K2, as holders of K2 visas, and they will be able to get their green cards together or after their parent.
What about if they were adopted children? You know how in the Philippines sometimes they adopt someone, a family or relative staying with them. Is that more complicated?
Well, adopted children in the Philippines are always more complicated because many of those adoptions are not formal and have no value in the eyes of immigration because they have not been done completely formal. And the other issue is that today, for the past maybe 10 years or 15 years, there have been new laws about adoption subject to an international treaty. We call it the Hague Treaty about adoptions. And the procedures are very special and very, very difficult, and it became quite difficult to bring to the U.S. adopted children.
Well, for those people who are interested in knowing more details, definitely they can retain your services and come for a free consultation. Is that correct?
Our office has been in the habit of giving free consultation. We consider it our duty and our service to the community. And anybody who wishes to get a free consultation all they need to do is they need to call our office and make an appointment to see me. I would advise them, if they are undocumented people, if they need a green card, to bring their passports with them. And I would advise them to bring with them any documents or any paperwork that was done previously in connection with the Immigration Service.
This has been an Immigration Update on the Air with Attorney Jack Golan. Awee Abayari saying goodbye for now. Thanks so much for watching. Call Attorney Jack Golan, 213-383-3222. Till then.